Welcome to The Debate. Today, we're diving into a section of the Constitution that, well, often gets overlooked because it seems maybe a bit administrative. Article VI.
Exactly. But buried in there is actually one of the most revolutionary statements in American constitutional history.
That's right. Our focus is on the final part of Article VI. It requires all federal and state officers to swear or affirm support for the Constitution. But then comes the crucial bit. It specifies that no religious test shall ever be required as a qualification to any office or public trust under the United States.
And this prohibition, the no religious test clause, it banned a type of government-sanctioned discrimination that was, frankly, pretty common across the Western world at the time.
Right. And the disagreement, the core of our debate today, lies in its lasting impact. So the question we're asking is this: is the main constitutional significance of this clause limited strictly by its original textually narrow function, meaning it just prohibits a specific qualification for federal office?
Or does its real importance lie in the foundational principles of religious liberty and equality that it introduced? Principles that perhaps transcended the literal text and were later applied much more broadly.
I'll be arguing for that second view, that the clause's foundational principles of non-discrimination and equality have profoundly transcended its narrow textual scope, essentially that its conceptual legacy is supreme.
And I'll be taking a slightly different angle. While I absolutely recognize its pivotal role, I'll argue that the clause's importance really needs to be understood within its historical and, importantly, its precise textual limits. That narrowness, I think, remains very relevant today, especially when we look at how the text actually operates or maybe fails to operate in modern constitutional law.
Okay, so let me lay out my position more fully. I see the no religious test clause as constitutionally essential, really because it established this fundamental commitment to religious liberty and equality. And that commitment profoundly influenced how we later came to understand the relationship between government and religion in this country. To really get how radical this was, we have to think about the context back then. This clause fundamentally rejected the dominant idea in the late 1700s that holding office was just a privilege, something reserved only for members of certain established faiths, usually Protestants, rather than a right protected by freedom of conscience. The source material makes it clear this was a huge shift. States at the time, they enforced really severe religious exclusions. Maryland, South Carolina, others, they required belief in God or the Christian religion. Delaware even required elected officials to swear faith in the Holy Trinity.
Right, the state level was very different.
Exactly. And the framers, right in the middle of this overwhelming consensus for religious exclusion, they nonetheless prohibited the practice entirely at the federal level. Now, yes, the resulting text was narrowly focused on federal office, I grant that. But the foundational idea, the idea that civil government couldn't use religious requirements to pick its leaders, that provided the intellectual bedrock for modern interpretations. That includes the First Amendment's religion clauses, which, universally prohibit this kind of discrimination today. I really think the conceptual victory was won right there in 1787.
Okay, that's a compelling argument about the principle. I see that. But let's think about the immediate political and legal realities the framers were facing. I believe the clause has to be viewed first and foremost as a precise, limited textual commitment. It came at a compromise, right? Not some boundless ideological declaration. Well, you correctly point out how severe the state qualifications were. But the fact that the framers created a ban only for offices under the United States, that says a lot about its intended reach, doesn't it? It seems highly pragmatic. I mean, if the clause was meant to establish some universal national principle of non-discrimination that applied immediately to state governments, well, it was either drafted poorly or maybe deliberately narrowly. And we know its inclusion caused a real stir during ratification. Opponents were passionate. They feared it would open the national government to, quote, Jews, Turks, and infidels. That historical resistance, it underscores just how politically sensitive and frankly limited this federal restriction was seen to be at the time. So the narrow text, I think, reflects a deliberate choice. Restrict only the national government, leave the states and their widespread religious tests untouched for the moment. And crucially, as we both know, The Supreme Court has never formally applied or incorporated, to use the legal term, Article 6 itself against the states. When the court finally did address state tests, much later, it relied on the 14th Amendment incorporating the First Amendment, not the direct authority of Article 6. That whole procedure, to me, confirms the original text's specific and limited textual boundaries.
Okay, I see why you're leaning so heavily on that textual boundary. But let me offer a different perspective on this tension, the one between the text's scope and the principle's power. You emphasize the state tests and the lack of universal application, arguing the framers were just solving a narrow, structural problem for the new national government.
Essentially, yes.
But I don't think the clause's significance is diminished just because its scope was initially limited to the federal level. Look, the framers had a tricky job. They had to design a structure that could bring together citizens from states with really different religious cultures. You had established churches in New England. You had much more liberal places like Rhode Island. They needed a neutral federal mechanism. By prohibiting a religious test, they were prohibiting, as the source notes, a long-standing form of religious discrimination practiced both in England and in the United States. The very act of rejecting this practice at the highest level of government, especially given the historical consensus accepting such tests, that was a deliberate step. Maybe cautious, yes, but ultimately a decisive step toward religious equality. It set a model. It planted a seed in the structure of the new national government. To say that because it didn't instantly overturn all the state laws, it therefore lacks foundational importance, that seems to ignore how constitutional development often happens, gradually.
I acknowledge the value of the principle, and yes, it was a critical step. But I have to press you on the consequences of, well, maybe downplaying the text's specificity. You're essentially suggesting we read modern principles back into what was fundamentally an 18th century compromise. The framers prohibited a religious test, and in that context, that meant an explicit oath or an affirmation of belief. They prohibited a mandated qualification. The evidence seems to suggest there was still widespread acceptance that political bodies could consider religion when judging fitness for office. They just couldn't demand a formal statement of creed.
Okay.
If the foundational principle truly was this comprehensive ban on all governmental consideration of religion and office holding, why didn't the framers put a broader anti-establishment clause right there in Article 6? They waited for the First Amendment, which came 4 years later, and even that still needed incorporation centuries later to fully reach the states. That gap suggests to me that Article 6 was really about solving a specific institutional problem. How do you unite these religiously diverse states under one federal government, rather than enacting some sweeping philosophical declaration for universal religious equality right then and there?
That's a critical distinction you're making. I see it. The difference between a specific institutional fix and a grand philosophical statement. And I appreciate the focus on the word test. But I'd argue the institutional solution required the philosophical breakthrough. The enduring principles that were inherent in that breakthrough, those are ultimately what shaped our constitutional landscape. And this, I think, leads us right into modern judicial precedent, specifically those rulings in Torcaso v. Watkins back in '61 and McDaniel v. Patty in '78.
Okay.
These cases, as I see them, they confirm Article 6's ultimate philosophical victory. Torcaso unanimously struck down Maryland's requirement that office holders had to declare a belief in God. The court stated unequivocally, and this is key, that neither the state nor the federal government can constitutionally force a person to profess a belief or disbelief in any religion. To me, this proves that the underlying ideal of equality, the one implicit in Article 6, is now the dominant constitutional norm. It overrode those historical state laws that had hung on for generations. That original state consensus was finally overturned by the, let's say, conceptual gravity of non-discrimination that was established first by Article 6 at the federal level.
I'm sorry, but I just don't quite buy that those cases prove the conceptual supremacy of Article V itself. I agree wholeheartedly that Torcaso and McDaniel established a necessary constitutional standard. They forbid religious tests at the state level. The outcome was absolutely right. No question.
But
However, if we're focusing on the textual and the structural significance of Article V, the legal mechanism the Supreme Court used is, well, it's everything. The court did not hold that Article V on its own terms applies to state office holding. Instead, the court relied on the First Amendment's religion clauses, both establishment and free exercise, and those were made applicable to the states via the 14th Amendment's due process clause. That's the legal tool known as incorporation, which, developed decades after the Civil War.
Right, the incorporation doctrine.
Exactly. So just to be clear for listeners, the court didn't just ignore Article 6, but they effectively ruled that Article 6, as written way back in 1787, was structurally insufficient on its own to reach the states. They had to use this much later mechanism, incorporation, to make those federal rights binding on state governments. Article 6 itself just wasn't built to do that heavy lifting against the states. So this procedural reliance on the First and 14th Amendments is, I think, structural proof of the limited nature of the original Article 6 text.
I'm just not convinced by that line of reasoning because it seems to elevate the procedural mechanism above the substantive constitutional value. Yes, okay, the 14th Amendment provided the legal lever, the tool, but the value being protected, the ban on religious requirements for civil office, that was explicitly established in the constitutional text through Article 6, almost 80 years before the 14th Amendment even existed.
But only at the federal level initially.
Right, initially federal, but to dismiss Article 6 as merely a limited text just because it wasn't the vehicle ultimately used against the states, that feels like it ignores its foundational role in establishing the very constitutional value that Torcaso eventually upheld. Furthermore, relying purely on the lack of direct incorporation is kind of like saying that until the 14th Amendment came along, the states just had a constitutional green light to discriminate based on religion, regardless of the principles the federal government was trying to establish. That feels like a fundamentally incomplete view of the Constitution's overall journey toward non-discrimination.
It might feel incomplete, but arguably it's textually accurate to the document as it was written in 1787. The framers made a specific choice. They could have tried to draft Article 6 to be self-executing against state requirements, perhaps, but they didn't.
Let's maybe shift focus slightly to some contemporary ambiguities, because I think they demonstrate why this textual precision still matters today. The clause only prohibits a religious test required as a qualification. That specific language, it leads to a very real and contested boundary line in modern politics.
Okay, like what?
Well, the source material notes a contemporary debate that perfectly illustrates this narrowness. Does the clause extend beyond prohibiting explicit oaths, like forcing someone to say, "I believe in God," to also prohibit government officials from, say, taking the religious views of an individual into account when they're selecting or confirming them for a federal position? Think about a Supreme Court appointment.
Right, the confirmation hearings issue?
If the clause were truly this boundless foundation for religious equality that you describe, why would there be such deep disagreement over whether it applies only to a mandatory formal oath versus a subjective political selection criteria? To me, this ongoing debate confirms the narrow focus of the original language on preventing formal, mandated exclusion based on a sworn oath.
I see why you raised that modern debate. It was perhaps the most vexing application of the clause today. It really is. But I would argue that extending the clause beyond just mere oaths to also include selection and confirmation criteria is absolutely necessary if we want to uphold the principles of non-discrimination and equality that the framers sought to introduce.
But is that what the text says?
Well, look, if the government can achieve the same result as the prohibited test, which is excluding someone based on their faith or lack of faith, but they do it via subjective selection criteria instead of an explicit formal oath, then the foundational principle of non-discrimination is, well, it's rendered kind of futile, isn't it? Think back to the ratification debates. Supporters of the Constitution argued that laws requiring tests were often ineffective anyway, because, dishonest individuals would just use sham compliance, they'd swear the oath falsely, while honest individuals who couldn't swear it would be barred. That same logic, I think, applies today. The spirit of the law requires us to view the clause expansively, especially regarding federal appointments, to ensure the principle of non-discrimination is actually effective, not just symbolic. Political exclusion based purely on religious belief is, in practice, a religious test, even if it's not a formal oath.
That assumes the framers' spirit was truly intended to prohibit all consideration of religion in political life, which I think the history doesn't fully support. Political judgment is inherently subjective, isn't it? The text is quite clear. It prohibits a test required as a qualification. A political consideration during a confirmation process, while maybe messy or even distasteful sometimes, seems to fall outside the specific legal definition of a mandated qualification test that the text addresses. Furthermore, trying to force government officials to completely disregard all religious views during confirmation proceedings, well, that might be a severe constraint on public discourse, something that the First Amendment itself, which protects the political expression of religion, might actually push back against.
But the key distinction has to lie in the nature of the exclusion, doesn't it? Article V bars mandated religious exclusion from office. If we allow informal political criteria to achieve that very same result, mandatory exclusion based on faith, then the clause just becomes a linguistic loophole, something easily circumvented. The purpose, surely, was to broaden the field of potential candidates to include people of all faiths and no faith. To honor that purpose, we really have to view this selection criteria argument as a necessary defense of the core Article V principle.
A defense that potentially stretches the text beyond its original meaning, perhaps?
Okay, so to summarize my position, the true legacy of the No Religious Test Clause lies not just in the specific words, though they are powerful, but really in the enduring and essential principles of religious liberty and equality it established at the federal level. This clause, I believe, acted as the constitutional vanguard. It made the first definitive statement against religious exclusion in public office, and it paved the way for a national constitutional commitment that eventually invalidated those pervasive historical religious exclusions at the state level, and that was confirmed, yes, decades later by the Supreme Court, but relying heavily on those Article VI values.
And I would conclude by re-emphasizing the persistent importance of textual boundaries. The clause remains a powerful, specific statement against mandated religious qualifications for federal office. That's crucial. However, the critical fact that its prohibition was structurally limited, requiring the later use of the First and 14th Amendments to reach the states, and the continuing, very robust debate over its exact reach into the selection process today, these factors underscore that its significance is best understood as a precise, historically bounded commitment within Article VI. It is an absolutely vital pillar, no doubt, in our understanding of religious liberty, but structurally speaking, it isn't the entire self-executing foundation of modern religious freedom law.
And this tension, I suppose, between that textual precision you emphasize and the foundational ideals I see, between the limited structure the framers created and the profound, sweeping principles those structures maybe inevitably introduced, it really shows how these early constitutional compromises continue to shape legal and scholarly analysis even today. The Article VI compromise might have been politically necessary in 1787, but the principle it enshrined, I maintain, was ultimately far larger than the text itself.
Indeed, and the analysis of Article V certainly demonstrates that while the conceptual weight of non-discrimination definitely bends constitutional history toward equality, we must always try to anchor our understanding of its function in the specific, perhaps cautious language the framers actually adopted, recognizing its intended constraints alongside its undeniably revolutionary impact.